afternoon, good evening from wherever you're watching me. My name is Namara Msinguzi. I'm an advocate of the High Court with over 15 years experience. I'm a construction lawyer and arbitrator. I'm a fellow of the Chartered Institute of Arbitrators, and I chair the Education and Training Committee of the chapter in Uganda. I would like to extend my sincere appreciation to our mother branch, Kenya branch, for giving me and the Ugandans that are part of this panel the opportunity to be part of this very exciting engagement. And we look forward to a very insightful and a very exciting 2 hours. So on to our motion, our topic for the day, the FIDIC conditions of contract, both the 1999 and the 2017 suite, provide for a multi-tiered form of resolving disputes. And one of those tiers is the Dispute Adjudication Board, as it is referred to in the 1999 suite. And the other is the Dispute Avoidance and Adjudication Board, as it is referred to in the 2017 suite. Under the FIDIC 99 suite, what was in place was a Dispute Adjudication Board. So that was a step before a dissatisfied party would go to arbitration. If you could not commence arbitration before appearing before the DAB, the Dispute Adjudication Board. Of course, before the arbitration, there is the period of amicable settlement. So before those 2 steps in the multi-tier, you had to appear before the Dispute Adjudication Board if you were dissatisfied with the decision of an engineer. And it's established under Clause 20.2, and its powers were majorly adjudication. Under the Red Book of FIDIC 1999, there was a trace of an avoidance mandate in 1999 FIDIC Red, just a trace. And the 1999 FIDIC Red was the only one with the standing DAB, hence the trace of the avoidance. The others in the suite did not have it, they had ad hoc DABs. So in the 2017 suite, they decided to harmonize and ensure that first of all, the DABs are all standing. Secondly, they introduced a new concept called avoidance, and that was introduced in Clause 21.3 of the FIDIC conditions of contract. So the DAB is established at the beginning of the project. It also provides for who appoints them, how they're appointed, how they're remunerated, and how they conduct their business. So one of the things that they do is avoid disputes. And they do it through a detailed way. There are DAB rules and DAB agreement that guide how they will do it. But also the parties can call on them to make a decision that is non-binding in the event of the project. If they feel that there is something that may lead to a dispute, the DAB shall then be called upon in writing by both parties to give an non-binding opinion. So that is the avoidance part of the DAB. It still maintains its adjudication role under FIDIC 2017, and is mandated to render a decision within a stipulated time. And again, it's guided by an agreement and rules as contained in the appendix to the conditions of contract. So under FIDIC 1999, it is a DAB. Under FIDIC 2017, it's a DAAB. So our dear participants, every construction project carries 2 budgets. The one printed in the contract and the one written in disputes. And this afternoon, we're going to ask a very critical question: whether dispute avoidance and adjudication boards are an investment in the first or an inflation of the second. Do they inflate the budget, or they actually control it and ensure that it's not inflated? And to answer these questions in this grand debate, it's my privilege not only to moderate what promises to be one of the sharpest conversations the branch has hosted this year, because we meet at a particular moment in East Africa where there's so many projects. Some of them are governed by the FIDIC conditions of contract, hence there are DABs in place, FIDIC 2017. And this question we need to answer in this debate: do dispute avoidance and adjudication boards earn their keep, or do they quietly inflate the very disputes they were designed to prevent? And as I said, it's my pleasure not only to moderate, but to introduce a very stellar panel, distinguished experts across the built environment that shall give us their sides of view. And at the end of the day, we shall choose whether The dubs are necessary expense, or they are not necessary at all. Allow me to introduce my panel, starting with the proponents of this motion. Cyrus Titus Aomu is a construction disputes and contracts expert with over 20 years of experience in infrastructure projects across Uganda. His special... Can you still hear me? Okay.
Yes, we can.
He specializes in dispute resolution, claims preparation and review, and FIDIC-based contract advisory with hands-on experience across the full project lifecycle. Cyrus is a FIDIC certified adjudicator and fellow of the Chartered Institute of Arbitrators. Cyrus serves on dispute boards, ad hoc adjudication assignments, and on Uganda's public procurement and disposal of public assets appeals tribunal. And he has been involved in resolving complex construction and procurement disputes. He brings practical insight from extensive work with government agencies, contractors, and development partner-funded projects, World Bank, AFDB, AFD, and is experienced in training professionals in construction adjudication and dispute resolution. Cyrus is known for combining technical engineering expertise with legal and commercial understanding, enabling him to deliver clear, practical guidance to construction and legal practitioners. Joining Cyrus is Mr. Kenneth Kampurira. Mr. Kenneth Kampurira is the Honorary Secretary of Chartered Institute of Arbitrators, the Uganda chapter. Mr. Kenneth Kampurira is the Managing and Founding Partner of Amber Advocates. He is a member of the Chartered Institute of Arbitrators and is often appointed to resolve complex construction and arbitration matters. He sits as an arbitrator as well and holds a master's in construction law and dispute resolution from Robert Gordon University. You're very welcome, Cyrus. You're very welcome, Kenneth. On the other side of the divide are two ladies that are going to oppose this motion. And one of these ladies is Honorable Lady Justice. Let me just get a profile a minute. Honorable Lady Justice Belinda Akello. She's an advocate of the High Court of Kenya, an arbitrator, a certified mediator, a certified secretary, and a financial analyst. She holds both a Bachelor of Laws degree from the University of Nairobi, as well as a Bachelor of Science degree in International Business Administration from United States International University, Nairobi. She has a postgraduate certificate in Public Administration obtained from the Australian National University and a postgraduate diploma from the Kenya School of Law. She holds 2 master's degrees, the first in Public Policy from the Crawford School of Public Policy at the Australian National University, and the second in Diplomacy from the College of Diplomacy, and also at the Australian National University. She worked for the Kenyan Truth, Justice and Reconciliation Commission as the legal director for 2 years, during which, among other legal responsibilities, she managed the conduct of nationwide public hearings and training of lawyers on transitional justice along with the Law Society of Kenya. She was a UN consultant for 3 years, stationed at the largest refugee camp globally, where she worked as an eligibility consultant and, among other duties, spearheaded the deregistration of fraudulently registered refugees and Kenyans. As an advocate with Muhammad Muigwai Advocates in Nairobi, she assisted in representing the Communications Management Authority in Kenya, actively contributed and managed the establishment of Kenya's communication regulatory framework. Her areas of expertise include constitutional law, corporate governance, corporate law and finance, environmental law and policy, climate change law and policy, multilateral environment treaties and agreements, negotiations and financing mechanisms, environmental and climate justice, litigation, and other mechanisms. Honorable Lady Justice, she's just been appointed to the court, to the Environmental Court, and we send her our heartfelt congratulations. And appearing with the Lady Justice is Miss Mercy Okiro, a fellow of the Chartered Institute of Arbitrators. She brings over a decade of post-admission experience to her practice. She has represented and advised local and international clients, particularly in alternative dispute resolution, election disputes, corporate and ESG governance, legislative and policy reform, construction and sports law. She serves as sole arbitrator, mediator, and construction adjudicator in disputes across various industries. Mercy is a member of the panel of neutrals in mediation and arbitration for several regional and international institutions. She's the chairperson of the board of the National Construction Authority in Kenya, where she also served as vice chairperson. She is the convener of the Law Society of Kenya Sports Disputes Tribunal Backbench Committee, an adjunct faculty member at the Kenya School of Law and Strathmore University. Additionally, she sits on the National Physical and Land Use Planning Liaison Committee. She's an active member of the arbitration community, serving as an advisory board member of the Lagos Court of Arbitration Young Arbitrators Network and a steering committee member of Equality for Representation in Africa. She has also authored numerous articles on sports law and ADR and has served on various boards in the private sector, both locally and internationally. She was an ICCF representative for African MENA region, sat on the steering committee of the Young Members Group of FCIArb London, was a founding chair of the Young Members Group of FCIArb Kenya, and at 27 years sat on the board of the FCIArb Kenya branch committee. She also served as an ambassador for the Alliance for Equality in Dispute Resolution, Arbitrator Intelligence and Racial Equality for Arbitration Lawyers. She also served as a vice chairperson of the KEPSA Gender Sector Board for 2 years, as well as the Sports Youth and Culture Committee. She holds a Masters of Arts in International Studies and Diplomacy from the University of Nairobi, a Masters of Laws in International Commercial and Investment Arbitration from Queen Mary University of London, and an Oxford Diploma in International Commercial Arbitration. Additionally, she has professional certification in risk management, construction law, corporate governance, trade law and policy, ESG governance, legal audits, arbitration, mediation, and sports dispute resolution from the University of Berkeley Law, FIDIC, ICPAC, ICS, and other reputable institutions. In 2019, she was honored as the Young African Arbitration Practitioner of the Year, and she was also recognized as one of Africa's most promising young arbitrators in 2020, 2021, and 2022 by the Association of Young Arbitrators. Additionally, she was named second runner-up as ADR Practitioner of the Year in 2021 by the Law Society of Kenya, Nairobi branch. In 2023, she received the Chartered Institute of Arbitrators Kenya's Jury Award for her contributions to ADR. The Women on Boards Network also celebrated her as the first runner-up in the category Woman on Board Award in 2023, and she has been recognized as one of Kenya's top 100 arbitration practitioners by Lawyer Africa in 2022, 2023, and 2024. So, ladies and gentlemen, please join me in appreciating our very stellar panel that is going to take on this very critical question. Are dubs worth it, or they are just another unnecessary expense? So let's start with the proponents. And I would like to start with Cyrus. The question is uniform. If a client called you tomorrow about a $50 million project, 17, would you recommend a dub or not? Yes, Cyrus.
Thank you. Thank you, Anne. I want to begin with a scenario. Many of you may be familiar with it, some maybe not. And it is called the blood clot scenario, and whether it's fatal or not. Now consider that you're a project and you walk into a hospital for your annual body checkup, and your physician tells you that you have a likelihood of dying abruptly from a blood clot. The physician also goes ahead to tell you that your condition is generic, meaning you probably got it from your folks. Then he goes ahead to say that the remedy for your condition is to take a blood thinner as a preventive measure. Now, many of you who know what blood thinners are will relate with this sort of scenario. Now, the blood thinner is a preventive measure, and it's supposed to prevent you from dying abruptly. I have a question, though I'm being asked to answer. Would you agree to taking the blood thinner? Now, I know that many of you would do what it takes to stay alive, because no one wants to die abruptly. Now, would I recommend a client on a $50 million project to go for a board? Yes, I would. I will give you the reasons why. Projects are prone to real-time challenges. Of course, these challenges can evolve into disputes, but challenges don't always have to become full-blown disputes. Now, under the DAB framework or the DAAB framework, avoidance mechanisms come in handy. And of course, the adjudication feature in this same mechanism is triggered when the board receives a referral for a decision. Now, Anne mentioned that under the 1999 forms of contract, we had a dispute adjudication board, and the avoidance function was silent, especially in the silver books and the 1999 yellow book. And that in the 2017 suits of contract, the avoidance function is more pronounced. That is true. Before I get into the discussion of efficiency under the DAB framework, I just want to go specifically and answer that question and then go a bit into some more detail. It is possible to have an avoidance function under the 1999 silver and the yellow book forms of contract that don't typically have this function. I was recently engaged on a board, and the parties wanted me to contract based on a 1999 yellow book. I eventually advised them to amend the agreement and the rules such that I would also give them the avoidance function and that they would enjoy the benefit of informal advice or informal opinions. So whereas it's not a feature that stands out in the 1999 books, if you talk to the parties and they understand the benefits of avoidance, they should be able to allow you to trigger that, to give you the jurisdiction to give opinions whenever they warrant. Now, why would I ask the client to, or whoever has approached me, to go for a dispute avoidance or adjudication board? Basically, what's the argument around efficiency? Now, the thing about boards is that you have the option of an early appointment, or to appoint a team that's going to help you manage these disputes when they arise at the start of the project. You can either have 1 member or 3 members. Normally, the number depends on the threshold of money involved. For 50 million, you're more or less looking at a 3-member board. Now, alternative methods are reactive and they are not preventive. They will not allow you have this mechanism at the beginning where you can enjoy the benefits of getting informal advice throughout your construction project or giving decisions in real time. Now, second issue is the parties enjoy real-time assistance under the avoidance function. Now, what the board does is to tactfully get the parties to talk about issues. Avoidance is not only about writing informal opinions or giving informal advice. Now, when you get the parties to talk, it's interesting that you find that you are alerting the parties and they are encouraging them to address red flags early. Some parties will not know they are going down a slippery slope. Some will know it, others will not. Now, this tactic alerts the parties and encourages them to address red flags early. In the process, what happens is that the parties get the skeletons out of the cupboards and they avoid walking on hot charcoal or hot coal. I don't know any other alternative method that will give and provide real-time assistance to the parties as they execute their project. Whether it's a 1-member board, whether it's a 3-member board, whether it's a DAB or a DAAB, I think there is still a lot of reason to go for this framework. Now, the tracking mechanism. What we do on sites is that we tend to have routine visits. And as the parties execute the project, the board arguably has a much better understanding of how a dispute could evolve or has evolved, rather than trying to understand what has happened at the next dispute resolution tier. Because when you move beyond above the spectrum to arbitration and litigation, you are faced with a panel that is pretty much trying to understand what happened, how the parties got there. With the DAAB or DAB mechanism, the tracking mechanism helps the board to have a very clear grasp of the matter. I do not know, again, any other alternative methods that have this tracking mechanism. I want to cede ground to my land friend, Kenneth, to let you know more about the specific question Anne has asked, unless she prefers to ask another one. Thank you.
Thank you very much, Cyrus. Kenneth, please take it on.
Thank you very much, Anne. I'll pick it up from where my brother Cyrus has left it. And being on the side that Cyrus is on, we don't want to look a little bit as if we've come to take on the ladies. But on the other side, we have beautiful ladies, and thank you very much for allowing to be on the other side. But I'll pick it up from Cyrus's point and say that we do advise in a $50 million transaction or deal for our client to definitely include a DAB. Cyrus has laid foundation on the formation of the DAB, either 1 or 3, and also given a perspective as to the advantages of having a DAB in place. Cyrus gave you the analogy of blood thinner. I want to add faith to it on the blood thinner. Mine will be a Psalms 23 perspective. Those who are Christians, even those who are not, I think we are familiar with Psalms 23. All of us who are faced with any situation that puts us into a very awkward place, we normally run to, though I walk through the valley of the shadow of death, I shall fear no evil, for thy rod and thy staff, they comfort me. I'll twist it, but I'll give it an analogy in terms of, though I walk through the valley of construction disputes, I shall fear no evil, for thy DAB shall walk with me and comfort me. Yeah, so why do we propose that the DAB will walk with you and comfort you even when these disputes arise? I think foundation has been laid properly in terms of it is obvious that every construction that goes up, whether infrastructure or even private, there will be some disputes that will arise in the middle or even towards the end of the project. I think the FIDIC contract does provide for scenarios where snags are likely to happen or where there could be an issue that needs to be resolved. And if we were to opt for any of the other alternative methods, believe me or you'll be walking into the valley of the shadow of the construction disputes if you have no DAB with you. I'll build on to the point of a speedy resolution of disputes. I come from a litigation background. I think you've heard I'm a lawyer. And I can assure you that in litigation and arbitration, you are bound to start at a very bad pace in terms of wasting of time, delay of the project. Delivery of the project will definitely be delayed without a doubt, I can assure you. The beauty about the DAB is that it's set up at the time of execution of the contract. Members are appointed, and they are on standby in case of any dispute arising. The beauty about that is that every time you have a dispute arising, you refer to the DAB, and the DAB will convene, and the claim will be put to the DAB, and parties will be able to exchange documents. The easiest is mainly on payments, payment certificates. I have read 2 authorities where payment certificates, over 200 payment certificates were disputed during the construction project. And all of them were resolved in the space of only 1 year. In other words, I think every month they had 10 or 50 of them, and they were resolved in 1 year. I don't know where you can get such a precedent. If you're litigating or going for arbitration, you're appointing an arbitrator on day 1. The arbitrator is signing off terms. The arbitrator is negotiating fees. The arbitrator is providing a schedule for you to file your claim, rejoinders, surrejoinders, submissions, witnesses, experts. This is more than a year of just preparing to start the arbitration. While I can assure you that under the DAB regime, which we believe is the Psalms 23, the DAB is working with you. Any snag that arises is not alien or even new to the DAB, because the DAB has inspected site on some occasions. An email has been sent on a possible claim that could arise, and the avoidance is mitigated by either an online meeting which could be set up by the DAB, or a physical sitting at site to resolve a simple snag or an extension of time if it's required. Circumstances are well laid out. If there's an extension of time, the DAB is very familiar with what has been happening. If there's been a change in scope or even a change in terrain in terms of a change of conditions on site, it is very obvious that actually the DAB will be very familiar with what has been happening, as opposed to nominating a fresh regime of arbitrators or especially adjudicators. Sorry, I meant to refer to arbitrators who are picked from different jurisdictions. Normally, the dispute is you cannot bring an arbitrator from Uganda to arbitrate a matter that is in Uganda. So we'll prefer people from Zambia, Kenya, South Africa. That is because the dispute has arisen. So now temperatures are already high. It is very hard for you to convene people and ask them to nominate arbitrators who are in Uganda. They'll prefer outside the jurisdiction. Those are costs. In terms of cost management as well, DABs do manage costs for reason that whereas there is a budget for the project, the budget for the adjudicators or the DAB is already set. There are no negotiations as to how we are going to inflate fees or we are going to inflate costs of the adjudicator to travel, to sit. All those are already factored in. Studies have already been made as to the cost, and this I picked from the FIDIC website, in terms of cost of adjudication vis-a-vis cost of arbitration. Costs of adjudication are normally limited or capped at around 2% of the project cost. While for arbitration, your starting point is 5% of project cost to 10%, and the costs are also at large. They could keep building up as they wish because you are busy procrastinating on when you'll sit and when you'll also convene the parties as an arbitrator. So you cannot manage costs, especially in arbitration. And I'll give a scenario. We are doing an international arbitration currently. I can't.
As you conclude, Kenneth, as you conclude.
Okay, fine. But our costs so far are at £200,000. Okay, so as I conclude, there's preservation of the relationship. Contractors and employers always start off at a good note. If there is any soiled relationship between the contractor and the employer, the project is likely to stall without a doubt because of altercations on extension of time, delay damages, and any other dispute that could arise in the course of the project. But where there is a DAB in place, parties are meeting every other day to resolve their disputes. So the relationship between the employer and the contractor is preserved. Work will continue going on regardless of the disputes that continue to arise. Lastly, as I conclude, okay, fine, I'll allow you to.
Thank you very much.
Thank you.
Thank you very much, Cyrus and Kenneth. Over to the opponents, and I will start with you, Mercy. The proponents have put up a very electrifying and solid defense to the theme: preservation of relationships, real-time resolution of disputes, working with you throughout the project. The cost is controlled; it is known. They have used very rosy examples of a blood thinner. I would want to hear from Mercy why you would rather have the clot when you have a solution, which is the thinner. Why you would rather go to arbitration or to adjudication straight, and yet the thing that would have thinned the clot of the dispute is the DAB. I would also like to hear from you and from Lady Justice why you wouldn't want such a great shepherd called the DAB, a shepherd that shall walk with you through the valley of the shadow of construction disputes, ensuring that you do not suffer any lack of any severing of relationships, any problem along the way, ensuring that the project is completed on time and on schedule. Why would you refuse such a good shepherd? Over to you, Mercy.
Thank you very much, Anne, the moderator, for this debate. I start by saying that the views I give on this debate are personal and are supposed to be affiliated with any institution I serve on. And I start strongly by referring to the example of DABs being blood thinners. Then based on that example, one thing that I should point out about blood thinners is that they don't heal. They just quietly stop clots being seen until the patient bleeds out. So DABs don't cure disputes, they just thin out parties' rights until the system itself is in danger. Distinguished colleagues, the proposition asks us to believe that DABs are efficient and cost-effective. My submission this afternoon is simple and direct. It is neither, at least not on the terms that matter most to us here in this region. We are in East Africa. We're not in Geneva, London, or Paris. This DAB system is just not designed for us. And I start with the fiction of the standing retainer. Let us begin with money. Efficiency begins and ends with cost. I'll give the example of a 3-member DAB on a 24-month project. This will cost approximately $180,000 in retainers alone before a single dispute is even raised. Of course, the proposition has told you that this is likely to be 0.5 or less of the contract value on a large project. But we are not all building standard gauge railways and mega projects. A significant portion of construction contracts in this region fall way below the USD 100 million threshold before that maths even begin to make sense. For the mid-tier locally procured infrastructure project, that is the usual waterworks, the county hospital, the rural roads, a standing DAB is not an investment, it is a luxury tax. My second ground, of course, that I then used to oppose this motion today is on the issue of enforcement. And I start by saying that the emperor has no clothes. The proposition's second pillar is that DAB decisions are binding and maybe even around easier to enforce. This is technically true, but then it is practically hollow in our general jurisdictions, that is Uganda and Kenya. Kenya does not have a dedicated statute on construction adjudication. We do not have an equivalent of England's Housing Grants and Construction and Regeneration Act. As such, we rely on our Arbitration Act 1995, perhaps the arbitration rules of the Chartered Institute of Arbitration, and these are arbitration rules. As such, a DAB decision is only as strong as the willingness of parties, or in this case, the employer, to comply. And on the record, I must then say that across Africa, we do have a documented pattern of the refusal of employers to accept and comply with DAB decisions. This is the feature of the landscape we exist in. Even our own courts have had to remind parties of their obligations. That is not efficiency. This is a mechanism whose efficacy depends entirely on litigation to enforce, which was supposed to be the very thing it was designed to replace. As much as the 2017 FIDIC suite has also acknowledged this vulnerability by mandating the ICC sometimes to resolve challenges against DAB members, this means, again, the oversight of this supposedly efficient mechanism still has to run to external bodies, parties, and other areas for enforcement. We cannot require such a dispute resolution method. Number 3, the DAB is a product of FIDIC, and as such, this is an importation again of foreign standards without African infrastructure. These standards were built on an Anglo-American common law tradition shaped largely by European and North African common law traditions. It was not designed in mind with the Kenyan, Ugandan, and I dare say general East African environment. As such, whereas sometimes the FIDIC 2017 suite is transplanted wholesale into our public contracts, the DAB clause frequently becomes the first casualty of negotiation. It is deleted, deferred, or simply ignored. Across the Middle East, North Africa region, and majority of FIDIC-based contracts, we remove this DAB provision entirely. That is not a coincidence. That is the market and the environment verdict on a mechanism that is not to be trusted, it cannot be afforded, and neither can it be enforced. We also face a talent gap, of course, and one of the largest costs associated with DABs in Africa is the engagement of members who do not reside on the continent. And I must say, the proposition has really brought this out, that they have to look for DAB members from other countries. Now, couple this with excessive travel costs. We don't have a standing panel in most of our states, as it were. Even in Uganda, the Construction Law Institute has only just recently begun building a panel of construction adjudicators. This mechanism requires routinely imported expertise that is not localized, and therefore it really is a mechanism that is dependency wearing the mask of efficiency. My fourth ground, as I oppose this motion, is the point around escalation being a strong selling point around why DABs are used. And even with the statistics being stated by the proponents, on my end, I also have different statistics that show that an optimistic figure of 80% compliance means that 1 in 5 DAB decisions proceeds to arbitration, taking with it all the cost of the DAB process plus the full cost of arbitration. In India's public sector context, for instance, a useful African parallel gives the scale of public infrastructure. DABs frequently function not as a resolution mechanism, but as a mandatory procedural hurdle. A 2025 Kenyan High Court ruling has confirmed that when a DAB is never constituted, parties can proceed directly to arbitration, effectively recognizing that the mechanism is all but optional. Madam Moderator, as I close, we are not arguing that disputes in construction should go unmanaged. We are arguing that the DAB as currently structured, priced, and transplanted into a legal and procurement environment does not meet the test of efficiency, cost effectiveness, and any other test really for the majority of the East African construction projects. This is a mechanism designed for a Zurich or Paris or Europe boardroom and staff from abroad, so we should delete it from contracts at the negotiation table, requiring us to use methods that work within our jurisdictions. Therefore, I oppose the motion. Thank you.
Thank you very much, Mercy. Before I hand over to Lady Justice, I have 2 follow-up questions premised on what you said. The first is in respect to cost. You said that projects in Africa were not designed for DABs. DABs are designed for projects in Paris and Geneva and countries of the same ilk. So you further said that if the project is small, then the DAB does not make sense, does not cut it. So my question to you is, if the project is substantial, would you then route for the DAB? Over substantial value, would you route for the DAB?
My submission still remains that in Africa, as it is, we should focus more on empowering our legal system to have our own construction adjudication mechanisms that apply to these jurisdictions that we are in and the environments that we are in, as opposed to borrowing the DABs, even in those large infrastructure projects that have not really demonstrated any usefulness, but instead have ended up being hurdles and we end up still escalating to litigation or arbitration. So I still oppose the motion and I answer in that manner. Thank you.
Thank you, Matt. Before I let you go, one final one. You gave us statistics and you said that 1 out of 5 projects, disputes before a DAB escalate to arbitration. Would that not be making a case for the efficiency of the DABs if 4 out of 5 are resolved at DAB level?
They're resolved at DAB level only for the purpose of the project to continue, but they're still eventually taken to substantive arbitration. Maybe my point that I should clarify is that 1 out of 5 essentially do not even accept the outcome, but the 4 out of 5 accept, but then they reserve their appeal they reserve their appeal to either go to litigation or arbitration as the contract provides or as the parties agree. So as such, it is a lose-lose DAB method.
Thank you, Mercy. Over to Justice Belinda Akello. Would you have a DAB in a contract or you wouldn't? You have said you wouldn't and would want to hear the reasons why. Over to you, my lord.
Thank you very much. And I think also as I start, I would like to start with a disclaimer very clearly that I am here as Belinda, the arbitrator, a member of FCIArb, not in my professional capacity, of course, not representing the views of the judiciary. And I'm engaging in this as an arbitration and an academic exercise. So I hope that goes clearly. Assign all my views to me as Belinda and not to the job or the hat that I wear. But now to your question before I give my points, and that will be my answer. My answer would be that DAB is like hiring a full-time private doctor. For you, because you know you might get sick, because we live, because you have gotten a baby, you get a full-time private doctor from Karen Hospital or from Nairobi Hospital. Now, having this conversation with someone from the village, they will tell you, what if I don't get sick? What if I get sick and maybe I don't have enough money to pay this person, this private doctor? But then we tell you, because you're born, the constitution of the land indicates that, yes, you must get this private doctor who charges you by the minute. But why am I saying this? those who are proposing DAB will tell you that A, it is efficient, and that B, it is cost effective. Now, what they don't tell us when they're defining it is that efficiency is more than speed. Efficiency doesn't mean speed to finish a case in 1 year. No. Efficiency means it has to be demonstrable efficiency. We have to see the progress of the project. It has to be accessible, the efficiency. It means that this resolution should not only favor a few or one side. It should be available to everyone, maybe free. And then number 3, it is efficiency that should be reliable. I should know that the same speed it holds for person A or for a small project will be the same speed it has for me. Does DAB answer that question? I doubt it. Now, the second issue that they've told us is that it is cost effective for you to have DAB. Now, let us temper cost effectiveness on a proportionality scale. What does that mean? It means that for the mechanism's cost, it can only be justified by the value it delivers at the end of the project. When you take the full spectrum of the project and of the parties who are supposed to use it, it should not merely work for those very big projects and ignore the small ones. Now, I'll give you my reasons, and then you'll tell me whether I think I support or I oppose this one. So the first one is I will put meat on what Mercy has already said. The first issue is the cost problem. Now, the costs of DAB are prohibitive. Looking at the FIDIC rules from 1999 to 2017, you'll see that, of course, there's a threshold for having a 1-member person or a 3-member panel. Now, what they do tell us is that every time the DAB expert sits, they earn about $2,000. Don't look at it in terms of dollars, look at it in terms of Kenya shillings. I shudder to do it in Ugandan shillings. I was in Uganda the other day. I felt like a very rich person. And then I converted it back to Kenya and reality sank in. Now, $2,000 is about $280,000 for you to have someone sitting. Please don't forget my analogy of a private doctor. You have a slight headache, you get a private physician, a surgeon to come and look at your headache. Not at all. Now, when they come to the ground, you pay, whether or not they come to you, you pay them a retainer fee of $2,500. Now, these are numbers taken from a few DAB contracts that we've had. $2,500, I was just doing my math, I'm not so good off it, is 350,000 Kenya shillings. Now, rough estimate is you will call these people maybe 3 times in a year, and in a normal 24-year, 24-month contract, you call them 6 times. Or that is about $180,000. Now, this doctor is charging you $180,000. Now, converted to Kenya shillings, that is about 45 million, 33 million Kenya shillings, or thereabout. If you do it in Uganda shillings, it is going to be almost twice that. Now, you're charging me, the Kenyan, you as a private doctor, for being sick. Now, those costs, in my view, could be a bit prohibitive, in as much as they can be able to help us. Now, number 2 is what I call the enforceability deficit. Like I told you, efficiency is not about speed. Efficiency is about accessibility. Efficiency is about justice. Efficiency is about meeting the end, justifying the means. So don't just tell us it's going to solve a problem within a year. At what cost and for who? Can everyone access it? All we want is a small road, and I'll take a Kenyan example, the Roroni interchange. But if it's going to cost the Kenyan person 45 million for you to do that stretch in 2 years, to come and look if they can have a dispute or not to determine it, then I tell you this value of the shadow of death, I might as well walk it in a Kala and not very original Nike shoes. Now, thirdly, remember the function of what a DAB is that there is a bit of a tension in that they are both advisory and they are both binding. When a DAB sits to give a decision, it is binding. However, if there is a dispute, the DAB, being an expert, could be an engineer, could be a lawyer, an expert who's been appointed because you have to be of a certain qualification, is going to provide some advice. Now, what would I do if I'm a party and I know that I want to increase my pay grade? Is I will go and seek advice. When this DAB expert gives me advice, and for instance, it's against my position, immediately I will file for a complaint. Now, this same expert is now going to sit and give me a binding position. Now, why for me that is the tension is that A, you give me a voluntary advice, And then B, you sit in Banco, you sit in bench again to determine and give me a binding decision. You will come and play the game lawyers do best. And I'm a lawyer, I can tell you this for free. Whereas they're binding, there is something they call the NOD, the notice of dissatisfaction. Whereas you will continue abiding by the decisions of this expert, once you file a notice of dissatisfaction or a NOD, you are ideally putting the other people on hold that I am intending to go on arbitration. What that tells you is that for the engineer, I might not continue at full throttle because I am going to be sued. I am going to spend another 2 years in arbitration. So what will a lawyer who I want, who is a very intelligent lawyer, do? Just file a NOD, just file another NOD. It is going to take even longer than going to court or for you going to go and sit in with this arbitrator. Now, the fourth issue that I have and I pick with DAB is as Mercy, my person indicated, this is Africa and Africa is our business. Let us not juxtapose ourselves to places where systems are above board. A system can only be as good as the people who are manning it. Do we have this level of expertise? Do we have the efficiency? And when I talk about efficiency, remember my first rider. Efficiency is not speed. Do we have power for us to be able to hold these meetings throughout? Do we have the infrastructure to have virtual meetings? Do we have the evidence, the scientific level of proof that is needed? I highly doubt it. Sometimes we will have to import and bring an expert from out of the country. Now, you are not going to bring a lawyer from London and fly them economy. You will fly them business. The amount of money you use for that could have already gotten an arbitrator in Kenya and solved this problem a long time ago. We don't have a basis, a venue, a body where you can go and sit. You will have to create it for this project. If we have 5 projects, how much are we wasting on what I would look at as transactional costs of getting a DAB in place? And remember, like I told you, this is like hiring a private doctor and you might never even get that headache. You might never catch malaria. Now, let us look at the regulatory framework in Kenya, and I'll speak more to the Kenyan system because I know it better. We want to bring in the DAB model, which is a FIDIC creation.
As we conclude,
Okay, as I conclude, our regulatory framework is already moving out. We have a bill, and which is called the I forget the name, but the Construction Payments and Adjudication Bill 2025. That means our parliamentarians have already seen that DAB is not satisfactory enough. They have already come up together with a whole new legal regime of how to deal with disputes. And finally, the concessions that come in with DAB are only as good as the value they bring. So what I would say is that whereas DAB is not a bad thing and it is a good thing, it is a tool too expensive, too dependent on laws we do not yet have, and too complex for everyday construction reality in Kenya. Thank you very much.
Thank you so much, Belinda. Before I let you go, I have a follow-up question. You have, yourself and Mercy have given us, you have demonized the DABs. And I would like to give an example of Uganda, where as per last year, statistics showed that over 6 trillion was stuck in court in commercial cases. 6 trillion. Let that sink in. So if the courts are not an option, if the DABs are not an option, then what is your option? Belinda?
Thank you very much. Alternative dispute resolution is an option. And I will tell you, and I not really rely on the Uganda numbers, I'll use the Kenyan numbers. Kenya has a slightly less number because it's in Kenya shillings of how much money is stuck in court cases. However, once you embrace, and we have embraced a process we call court annexed mediation and things like that, adjudication, then you find that you really don't need to be stuck in court. And what is holding people in court is the process. The complexity of the process is what holds people in court. Now, whereas we acknowledge there is a problem, which is what DAB is supposed to solve, we are not saying remove DAB and leave a vacuum. We are saying get a fit for Kenya, get a fit for Uganda. Don't get a private doctor and you could take what in Kenya we call maramoja, a very simple painkiller, and you get it. We need to have a fit process for our construction models. We need to invest time in how we outline and design our projects, and we will already be able to hold it back. So whereas DAB is not the best, is not, I'm not saying it's the only one, it is not the best. We can find the best model we have. The experts and the solutions are with us.
Thank you very much, Belinda. I waited to hear the solution, and I think I missed it somewhere. The final one, the very final one, before I let you go, you spoke about efficiency, and I would like you to help us understand, would you not be throwing out the baby with the bathwater when you say that we lack the expertise, we lack the efficiency? Would it then not be a question of building expertise other than saying DABs cannot work because there's no expertise? Belinda?
Thank you. So we don't have the expertise now. That is what I'm trying to say. What I'm trying to say is that the efficiency we are looking for has to be demonstrable. We should invest, and it works with the mining contracts that we have, which is what we should import into the construction system. What do? You then have, when someone is coming to do a big project, World Bank, for example, are the ones who do these big construction projects. Capacity build people. Capacity builders in a way that when I'm going in with Mercy into a contract, I already know the avenues I can use. So build our capacity. Have terms such as technology transfer. What will that do? It will make it accessible. What I shudder from is the mere cost of what DAB is. You know, it's like a wolf in sheepskin. It is sold as a very nice sheep, but it actually eats into us. What does it do? It eats into the money for our schools, our money for our hospitals. So whereas it solves something, it's going to leave us without any medical care. So that's all I'm saying. Let us find the actual help that we need of the efficiency. Build our capacity, give us the right technology that we need, and make it accessible to everybody. And we will take it. So we're not throwing the baby in the bathwater. We are saying, just make the bathwater the right temperature for us. We'll keep the bathwater and the baby.
Thank you, Belinda. Just a rhetoric. You don't need to answer this question. You have alluded to DABs eating up money for all these projects for the citizens. But we also have, if a dispute is not resolved in time, and the project stalls, then it's the same effect. But that is just food for thought. I'll come back to you. Thank you very much. The opponents, you've put up a very solid fight. And back to Cyrus and Kenneth. We have been told that blood thinners they don't serve any purpose, because as soon as you get off them, you'll die. We've been also told that getting a dab is like getting a retainer, doctor on retainer when a baby is 1 month old or 1 day old. What if that child, and a retainer for life, what if that child never falls sick? What if that child only has a simple cold that can be treated with a syrup from the pharmacy? Then how would you explain the money that has been paid to the doctor for all those years? So Cyrus, I'll start with Cyrus and I'll go to Kenneth. Please respond to what the opponents have put up, especially to do with costs, but also to do with enforceability. I would like to speak for Uganda. We do not have a law. We only have contractual adjudication. So we have that lacuna in enforcement as well. There's a case that went to court, and the lawyers were very clever. They tried to enforce an adjudication decision as an arbitration award, and the judge saw through them and said there was no arbitration award. This was an adjudication decision. So please, we are not going to enforce it as an arbitration award, and the case was dismissed. So we are yet to try the ground with a summary suit, since this is contractual. But that is the elephant in the room that Cyrus and Kenneth should address. What happens when you have a DAB decision and you cannot enforce it? No node has been issued, no arbitration has been commenced, so you have this thing that you cannot enforce. What do you do? How do you deal with the enforceability? How do you deal with the cost? Or especially on small projects. And also, it coming from the opponents, it's very presumptive. You presume that a dispute will arise. You presume that your baby will be sick every month. In the event that that doesn't happen, will that not then blow up the cost instead of just limiting it? Over to you, Cyrus and Kenneth.
Thank you very much. I will answer a few of the opinions from the other side. I will let my land friend deal with enforcement, but I'll chip in if I have to. Now, I want to say something. I have noticed I'm the only engineer on the panel. I did not quite imagine that this is how it would pan out. I mean, the arguments quite good, but let me make an attempt. Okay, I want to tackle the issue of luxury tax. Okay. I think that it's not compulsory. It's not compulsory to have a 3-member board. It's also not compulsory to have a one-member board. It depends on how the parties assess the risk on their project. Okay. When it comes to fees, I will give you an example. There is a board I sit, and I negotiated with the parties that they pay a retainer of a certain sum, but they also pay a daily fee. Now, what we did was cap the daily fee. And we went further to state that I will charge per hour, because it was pointless for me to have a meeting, sit down with them for 30 minutes or 40 minutes, an online meeting, and charge them the daily fee, which some fees, it's true, some fees reach the level of $2,000 a day and so forth and so forth. I think that business is business, professionalism is professionalism, and negotiation is always part of the game. If you feel that someone is expensive, you can negotiate. However, there's a limit to which, below which normally some professionals can go. Now, also the costs of adjudication, if you bundle up the costs are 50-50. If an adjudicator is charging you $2,000 a day, don't look at it as $2,000 a day. Look at it as I am the other party, I am probably paying $1,000. You could go further and say, look, even the $1,000, I'll only be paying $100 an hour. For instance, if the parties decide on time sheeting the time-based input. Okay, I don't think that we should have this fixed in our minds that if you engage a board, you're paying them a daily fee, and it's only a daily fee that you can pay them. You're paying them a retainer, and it's only $2,500 that you can pay them. Okay, I think that a certain level of experience and competence and quality commands a certain fee. Now, on the issue of experts, I think we owe it to ourselves, Kenyans, Ugandans, and everyone in the region, to support and nurture people and give people the confidence that they can actually get the competence in providing the service. We have experts within the region. Okay, I agree. There are few. Okay, experts within Kenya, Tanzania, and Uganda. Now, when the other side says that we are building infrastructure in Africa, okay, I just want to say something. A road is a road. A building is a building. A water treatment plant is a water treatment plant. So whether you're building it in France, whether you're building it in the Philippines, whether you're building it in Nicaragua, in South America, a road is a road. Okay, some specifications will change, okay? But by and large, if you're building a road, you're building a road. Now, what's interesting about disputes is that you can build a road for 20 kilometers and you can have on the other side a 100-kilometer road. The disputes are the same. Sometimes there are more complex disputes on small value projects or projects which are, let's say, of a smaller length, to use the context of a road. I also want to give you another viewpoint. Based on the submission earlier, where the board could give informal opinions or informal advice. In April, I issued informal advice to parties on a contract where I'm a dispute board member. The cost of that informal advice was $5,400 only. Now, $5,400 is, I don't know how many Kenya shillings, but it's about 18 million Uganda shillings, okay? That matter that the parties had could potentially have blown up into a dispute. At $5,400, I lit sufficient light bulbs in the minds of either party, and they were able to agree on the matter that was brought before me. It was simple informal advice, and it helped the parties. Now, if they probably had no board on that project, and they had cascaded onto arbitration, I think we'd have multiples of that sum. So I just want to say something about, again, deleting DAB clauses from construction contracts. Fortunately, I used to be involved in packaging bidding documents for tender about 10 years ago. And normally, when the contractors learned that there was no dispute resolution clause or there was no board on the project, they came to us and said, okay, during the pre-bid meetings, they said, can we please include a dispute board on the project? Now, for some reason, some contracts didn't have them, some contracts had them. But the point I'm trying to make is you are likely to get an increase in a construction cost if you do not have a dispute board on the project. And then the other thing I want you to consider is, like you said, we live in Africa and we are building a number of things. The question is, who are the contractors that are building these things? Are they native contractors? No, they are not. The contractors that we have building this infrastructure are contractors from abroad. If these guys get wind of the fact that you have no dispute board provision in your contract, you're likely to get a tender which is going to be 15% higher than it would have been. And that will even be much higher than the cost you would have spent on a board throughout the execution of the project. I want to cede ground to Kenneth to say something about enforcement and anything else that I may have left out. Thank you.
Before Kenneth comes, Cyrus,
Yep.
still on the issue of cost.
Yeah.
Imagine, not an imagination because it's reality, the retainer fee that is paid to each DAB member. Imagine it's a three-member DAB, and they're paid retainer every month. You have to fly them in if they are not in the country. So how would you, and then no dispute arises throughout maybe the 5-year life of the project.
Yep.
Then how would you then argue that DABs are still a cheaper option to other forms of dispute resolution?
It's a very simple answer. And the answer is we need to consider the DAB service or the DAB service as an insurance policy. If you have a car of 300 million shillings, let's say Uganda shillings, and you take a premium of 4 million shillings every year, okay, to cover this vehicle. So when the vehicle crashes, the insurance company is returning maybe 280 million shillings to you, you can repurchase the car. So there is no guarantee that you will have disputes on the project. Our cardinal role is to avoid them, not to wait for them to occur. Avoidance is as cheap as I mentioned, okay? The issue of, so when you bundle up the costs of the dispute board service, I want our takeaway to be that we need to consider the fees as an insurance policy. And once we understand that, it will be easier to comprehend and accept that you can put in money and not get a dispute. At the same time, you may not engage the board and you are struggling or suffering from a project that has stalled because disputes can't be resolved. Thank you.
Thank you, Cyrus. Over to you, Kenneth. Kenneth, Belinda said she'd rather walk through the valley of the shadow of death. She used a certain term there that I didn't quite get, but she'd rather walk through the valley of the shadow of death than pay a doctor a retainer from when the baby is born, even when the baby may never fall sick. So if they'd rather walk through the valley of the shadow of death or the valley of the shadow of construction disputes, then why would you still make a case for a DAB? The opponent said would rather walk through the valley than waste money. Kenneth, please answer that, and also please answer the critical aspect of enforceability. Thank you.
Thank you very much, Madam Anne. I thank the ladies who put up a spirited fight, close to ours, but I think we're still ahead of the justification for a DAB's existence. I'll still stand on the point made by my brother Cyrus, specifically in respect to the insurance policy. If my dear sister Belinda wants to walk that journey without any guardian angel called the DAB, then you have totally thrown away your insurance. The baby might not fall sick on day one, but the baby might be diagnosed with another complication in the lungs that you did not foresee. Would you rather let your baby live on chance, or you're better off ensuring that your baby has an insurance cover? In the unlikely event of anything going wrong, they are safe. I think I'll also remind our dear sisters from across the board in Kenya, and I also need, I think, some disclaimers here. The views represented by me are not intended to create a war between Kenya and Uganda. But I'll remind my sisters, the FCIArb conference in Rwanda, where their own senior counsel, Githu Mugai, did put us to task as African practitioners and lawyers. His closing remarks were, now is the time for Africa to shine. Now is the time for professionals to arise. But one big homework I give all of us, get competent. Be competent at the job. Be ready for the opportunity by being competent. So please, let's get competent. Belinda and Mercy, I beseech you by the mercies of God, get competent. Start to read. Do not alienate yourself from opportunity that has come to Africa. Would we call DABs to be a foreign phenomena? I'd want to say no. You cannot lock yourself out of advancement of technology and better ways of doing things. If we hide ourselves under the table, then I think as Africa will have lost the ball, in my view. I stand strongly to say that we need to get competent as Africans. We don't need any new law to be able to get competent. I think we don't need to reinvent the wheel by trying to create our own agreements when there are agreements that work. So Belinda and Mercy, I beseech you by the mercies of God, don't reinvent the wheel by creating special contracts when there are already existing contracts with better mechanisms that have already been tested and found to be true and watertight. Reason for departure from arbitration and adding the tier of DAB is simple. If arbitration will give you an award in a year or two, why not adopt other ways where the tribunal, that would be an arbitration tribunal, works with the contractor and the employer through the valley of the shadow of disputes, whether anticipated or have arisen, hence the DAB. So the DAB is a first tier, but meant also to ensure that disputes don't escalate, projects are concluded. I'll straight away run to enforcement. I'll give a scenario of Uganda. We had an institution that was in charge of roads, the Uganda National Roads Authority, and it did apply the FIDIC contracts because of the donor funding that we're receiving for all contract works for roads. The first case that they handled, okay, might not have been the first, but one of the cases that brought a lot of damage on the budgets of our infrastructure development was Uganda National Roads Authority versus Dot Services. The dispute involved prolongation costs and idle equipment. The dispute was filed in our commercial court, typical litigation. That is the one that you're advocating for, Mercy and Belinda. The outcome of the dispute was a whopping 29 billion judgment against the Uganda National Roads Authority. There was no budget for 29 billion bounty being awarded to a contractor. From that day onwards, UNRA chose the better way of handling disputes. That was using DABs as the alternative before you go to arbitration or even seeking any litigation. It is documented that 80 to 88% of disputes that arose during all our infrastructure disputes were resolved at DAB level. Only 18 to 19 went to arbitration. But even those that went to arbitration, 80% of them, the arbitrators ruled in agreement with the DAB. It does show you one thing, that efficiency does exist at DAB level. Comparing the 29 bounty with no budget in a decision of court to recover against a national institution that is charged with infrastructure development, vis-a-vis an 80% success at DAB level, I think speaks for itself. That we are now at a level where we need to move away from the traditional ways of dispute resolution, that is arbitration and litigation, to adjudication. Belinda, thank you very much for supporting us by informing us about the construction payments bill, which is in Parliament. I'm alive to that bill as well. That bill seeks to introduce statutory adjudication. Payments plans, payments redemption are a bonus for contractors. It seeks to introduce the aspect of pay now, argue later. In other words, if you have a DAB decision, pay what has been decided by the DAB, and then you can progress onto the arguments that you want to raise in litigation or arbitration. But before you pay, you cannot go for arbitration or the litigation. In other words, efficiency and management of cash flow at construction level. So the contractor is in for a big deal at this level. What does that tell us? That actually, even at DAB level, we are still behind the mark. We are now supposed to be chasing what Kenya has now achieved or is trying to achieve by having a bill. We are not behind the mark.
The question on enforceability as you conclude, please.
Okay, thank you very much. So enforceability, again, I'll ride on my sisters, Belinda and Mercy. You are ahead of the curve as Kenya. And I must tell you that you have successfully been able to at least enforce a DAB award on your side. I'll cite the case of Sogea Santon versus the National Irrigation Authority. I think Kenya has led us into a space where we all want to be as DAB practitioners or as those who are looking at DABs. In Sogea, Kenya drew the milestones that have been achieved by South Africa. There are over 200 authorities on SAPLI, if you're to check, on enforcement of DAB decisions. It is now a laid principle that a DAB decision is contractually enforceable. Parties have chosen to adopt a DAB as their first tier of dispute resolution, with a timeline that after 28 days and there's no notice of dissatisfaction, that decision stands and is enforceable as against the party who has defaulted on the DAB. So in my view, enforceability, now is the time, now it's available to be tested. In our scenario as Uganda, the authority that my land sister mentioned, the judge felt, I think, let down by the lawyers, with all due respect, because they chose to enforce the award as if it were an award in arbitration, but it was an adjudication decision. They should have enforced it by way of a special endorsed plaint that parties have agreed to be bound by a DAB. Parties have a DAB decision or a DAB award, and they seek to have it registered or seek to have it enforced as a special endorsed plaint or by way of summary procedure. You have successfully done it in Kenya. We are following behind your tracks, and thank you for supporting the motion as it stands. Cheers.
Thank you very much, Kenneth. I think the question still lingers, the question of enforceability. In the absence of a statutory regime, how would you enforce? We are going to test the waters very soon and file a summary suit, but you will agree that enforceability is only easier when there's a statutory regime. So over to the ladies. Ladies, I have a question for you.
And before you go, can I
Your time is up.
I wanted to answer that last bit of enforceability.
In 2 seconds.
Thank you. South Africa has no statutory regime on adjudication, but the courts have adopted the jurisprudence in Singapore and as well, but mainly Singapore, in terms of a decision of a DAB arose out of a contract of the parties. Parties have agreed to be bound. So it is by way of court enforcement as well, but you enforce it as if it were a contract of the parties.
Thank you, Kenneth. Thank you, Kenneth. There's
hope I've
jurisprudence in those. Yes, you have, but that is persuasive, for example, to Uganda. So it still remains the sticky issue of enforceability in Uganda. So over to the ladies.
Me on the instructions, I will charge a small fee.
Over to the ladies as we prepare to open it to the plenary. Both Mercy and Belinda rejected the blood thinners and the good shepherd. So if you have rejected the thinner, the shepherd, and the insurance policy, what is the alternative? What really is the alternative? Is it arbitration? Is it silence? Is it write-offs? Is it abandoned projects? What is the alternative to DABs? Belinda mentioned ADR. In my opinion, DABs are a form of ADR. So if it is not DABs, what is the alternative? Mercy, then Belinda. Thank you.
Thank you, Madam Moderator. And I've listened to the rebuttal by the proponents of this motion, and they've requested us or asked us to join them in the name of Jesus. But you see, the same scripture also provides us to test every spirit, and the spirit, in testing the spirit, we are not in support of this motion. To answer your question, Madam Moderator, we are opposing this motion by looking at the facts that are on the ground and really not on assumptions or philosophical arguments. A lot of the studies on which we can base success or non-success rates, actually, perhaps the leading study is the King's College London study of 2019, and data was collected in maybe over 4,000 or thereabouts, number of dispute boards. There is no data in Africa. So apart from those perhaps who are involved in day-to-day work in this realm of practice, then there's no data that proves. However, to answer your question, we do have data on the successes of court-annexed mediation and generally mediation. So the alternative to my argument and my submission is that the alternative to a DAB is not that we keep quiet, because parties in Kenya and really, let me say East Africa, we resolve already construction disputes through direct negotiation. Engineers also do determinations. We have ad hoc mediation and arbitration. We have institutions, arbitral institutions that have entrenched, and we have more capacity mediation, negotiation, and arbitration. I must also add that the spirit of Ubuntu within this continent of ours, negotiation is welcome and we use it day to day. So that at that point, capacity even comes from a cultural perspective. And I must say that the idea that without a standing DAB that the construction industry will descend into chaos is not true, because this assertion is not supported with any evidence from our particular jurisdictions. Now, indeed, being in East Africa, we are not all blind in terms of stalled projects, but I must then submit that abandoned projects in East Africa are not primarily a product of unresolved disputes. Indeed, the main causes are budgetary allocation, underfunding, procurement disputes, delayed payments by public employers, and also even political interference in some cases. As such, problems of this nature are primarily projects that a DAB, even if it existed, would not really resolve. Further, I must also say that the realities then in Africa as it is that most of these public projects that end up even adopting the 2017 suites are public projects, and most of those disputes, as I've said, are even outside the realms of what we can say legal in its strict legal systems in their strict sense. They are political, they are public, they are budgetary. And a board of 3 engineers or 3 or 1 construction adjudicator or whoever is picked in that DAB may not really resolve them in reality, retainer or not. So my submission is that I invite the other side to separate really 2 things. One, where are we inviting these DABs to be done? Where is the data? Our courts, both in Kenya and Uganda, have recorded extreme success by use of mediation. Negotiation is already in the spirit of our cultural, let me say, how we are as a people. So that when you say that DABs, once they are removed, then this industry and the disputes collapse, it is not true. There's no data to show their effectiveness really in Africa. Yet we have data on mediation, we have data on negotiation, engineer determinations, and really I must say that there is more respect for engineer determinations because of the technical expertise at the site of the disputes. And therefore, what I will say is that we have our institutions. Mediation is a very good alternative. And I must also add that apart from mediation, we have negotiations. A lot of the disputes even are determined without going to DABs. So the few that are being demonstrated here are successes in East Africa. Where is the data? There is none. None has ever been collected. And that is why the data that is used in support of DABs is largely data from Europe, as per the King's College London studies of 2019 and others that are continuing. That is where I'll submit, and I cede my additional time to my co-panelists in opposition of this motion. Thank you.
Thank you very much, Mercy. Just still on statistics, you rightly say that the King's College London yearly release statistics of how many disputes are resolved at adjudication level, and they're over 90%. Do we have statistics that show that in Africa, DABs have failed, that mediation and arbitration have resolved more construction disputes than DABs? Or are we speaking generally? Mercy?
Thank you. Our judiciary, I'll refer to the judiciary in Kenya and the allusions even of the judiciary in Uganda. Mediation has been tested, and mediation cuts across all sectors. That is data I can say. Number one, the Kenya National Bureau of Statistics, the National Construction Authority, Kenya Construction Industry Outlook, all these studies have shown studies of disputes in the construction industry and have shown mediation to be leading. They have also shown arbitration. They have also spoken to negotiation. So we have studies on that, but there are no studies on construction adjudication in Africa. And as such, we are philosophizing this because it is only limited to those who participate. Have they given us the full picture? As I have said, we have the full picture on mediation, arbitration, negotiation. I don't think so.
In Uganda, Mercy, we don't have any statistics on how mediation has resolved more cases than adjudication and DABs, but I will leave it at that, and I will go to Belinda. Belinda, you vehemently submitted on cost as one of your grounds for opposing the motion. So about cost, and because the board is standing, would you rather that it's an ad hoc, if it were ad hoc?
Thank you very much. Thank you very much. And let me answer it by just making one very quick point on enforcement that was really itchy. And I wanted to persuade our proponents. You know, when we have nodes, and this is statistics from Mozambique, now even outside Africa, Kenya and Uganda, it has actually been established as a scientific issue that because of the nodes being given, they are being structurally being used as a negotiation tool, so that the DAB does a decision, you give a node, and then this node acts as a negotiation precursor rather than you being bound, so that people use it as a bargaining chip rather than actually employing the benefit of what the enforceability. But as I go to the issue of cost, first, I'd like to dissuade what the proponents are trying to tell us. Two things they have said, and then I'll answer your question on whether it should be ad hoc or not. The first one is, don't look at it as, don't look at it as $2,000. This issue of DABs, I tell you, for most of us, and I speak, it's a job that I get. You earn $5,000 for evading a dispute. It is going to be $2,000. That is the first issue I wanted to dissuade you from. The second one is when you said that it doesn't have to be $2,000, we can negotiate it down. Then we bring a very structured American $2,000, and then who I know charging me $2,000 like a European or an American. The minute you start having double-sided standards for cost, the guy who was my pupil master said very aptly, Africa must shine. If we are paying $2,000 according to DAB, let us not reduce that amount for Africans. Let us not negotiate our brothers down, or from Uganda or from Tanzania. Let us agree that we will deal with the $2,000. So if the problem is $2,000, let it not be a problem for according to where you come from. It should be a general problem. Now, this structural problem can be solved by something, and allow me, I was just trying to learn it. I'm told in Uganda, and don't take it if I say it wrongly, there's something called kukika imbaraza, or akiriket, or I look, or mato, or put. What am I trying to come to? I'm trying to go to where the moderator was taking us. So what is the solution? The solution is to have an Africanized DAB. We know that it doesn't warrant $2,000 a day for you to come and help us resolve our disputes. Your Kukika Imbaraza will solve a land problem without charging you $2,000. What we are trying to say is, let us find our own. And you know, Ken was trying to tell us that, oh, not everything foreign is bad. But we have a system. My co-panelist told us we have Ubuntu spirit in us. We can resolve it without it being a source of income, because this is income taken away from what we would have otherwise been able to get. So let us recraft it so that we get it properly. And if you look at all these things that DARB is doing, it is actually being a precursor for negotiation. So let us just embrace negotiation from the word go. Now, what should we make it ad hoc? It doesn't necessarily have to be ad hoc, moderator. However, it is the prohibitive nature of what DARB is that I am currently, and we're trying to convince our brothers, we are currently against. We are not yet there as Africa, as East Africa, for us to be charging $180,000 for a would-be problem. However, we can charge something that we can solve. And we know that talking is in our business. We are Africans. Africa is our business. We can do it in a different way. Kenya has now done it. And our parliamentarians have seen the folly of importing this foreign issue. Now, the other very interesting thing that I've learned after having interacted with a number of foreign systems is that the World Bank and these other big institutions, they only impose it on us where there is a lacuna, where we are missing. If the World Bank came to Africa and we told them, Kukira in Baraza is working very well, or Njuri Njeke in Kenya is working very well, they're not going to breathe DARB down our throats. They will tell us, can we see the efficiency of what it is that you're doing? Here it is. Then we will be able to adopt it. Actually, the West is not always very quick to force us to take their systems if we have an equal and equally effective system. So what this DARB should let us do is to create a system that works for us, that doesn't fleece us of what we are marginally getting right now. That is what I think I would say for now. And like I said, of course, earlier, DARB for most of us is an avenue for jobs. It's a source of income. It is what we do so that we can earn a better living than we would solving disputes back home. So let us remove it, because these constructions are things that we need. And remember, our roads are not mega projects. They are small projects. DARB sits regardless of the size of that project. No, what we're trying to say is, like I said earlier, let us find the right temperature for the bath water. We don't need to pour the bath water. We don't need to pour the baby. Find the right temperature for us as Africans, as Kenyans, and as Ugandans, so that we'll be able to shower and enjoy all of this together. Unless there's something else I didn't speak to, moderator.
Thank you very much, Belinda.
I must
yes,
interject just because as I was finishing my conclusion, the study I refer to specifically on the effectiveness of mediation, and really mediation, court annexed and private, is a Kampala International University study of 2022 that concluded that mediation actually is a method of dispute resolution in Uganda that is of been great success in the administration of justice, primarily by reducing backlog, etc., and even cutting costs. That is a study I refer to, a 2022 Kampala International University study on the effectiveness of mediation and negotiation in the administration of justice in Uganda, just so that I can be correct on that. So there is that study, not judiciary done, but it has been done. Thank you.
Thank you very much, Mercy. The study that you referred to speaks about ADR generally. I thought it would be as specific as the study done by Kings that says that matters that are resolved at adjudication are 90% that don't proceed to arbitration. I was looking for such a study. Thank you very much, Mercy. But thank you for the statistics. They are very welcome. And now over to you, Belinda. You spoke about a node. You said the node has been used as a bargaining chip, and many disputes do not go to arbitration because of the node. So are you not in a way making a case for the efficiency of the DARBs? Secondly, the issue of the fees. If the fees were reduced to fees that an African could afford, would you then cross over to the proponent's side? And thirdly, you speak about Ubuntu, you speak about Mato Oput. Those are Mato Oput is a type of African justice system of resolving disputes, and it is common in northern Uganda, where the elders of the clan will meet with the accused and the families of the accused and the complainant and reach a solution. So if we are to use AGS and Mato Oput on construction projects, which are very complex and require experts, I'm not so sure how Ubuntuism would resolve a question of quantum, or a question of an unpaid certificate, or a question of lack of access to site, or a question of liquidated damages that have been levied. Do you want to respond, Belinda or Mercy, or I can now open it to the plenary?
I can make a quick comment and then I'll let Mercy also speak to it. And I'll start with your last one. You see, the reference I was really saying when I was going to Matoput and Kukira in Baranza is the spirit that you're bringing. Now, when I was explaining how node is structurally being used, is that node is now taken as a bargaining tool for negotiation. What is negotiation? Negotiation is the spirit of Ubuntu. It's the spirit of dispute resolution. It's the spirit of Matoput. It's the spirit of Kukira and Baranza. It's the spirit of Njurinjeke or the Luo Council of Elders that we have. So what I'm trying to say is that the underlying thread is negotiation, even with the dabs. The underlying thread is for us to come and agree. And even our first proponent, Cyrus, told us that he was able to bring the parties to realize the issues and agree. Now, that is what we should capitalize in. That is the crux of the matter, negotiation. How best do we do it? Now, again, if I am going to cross, which I am not against, but I will cross it on two conditions. A, the fees is moderated. B, we rename it. And 3, we reculturalize it to Africa. And then, of course, we are not going to call it DAB. We'll call it a name, whatever we want to call it. But it will now not be called DAB. It will not be offensive to us. It will be actually effective because we know our negotiation systems are able to work. And then we will be able to work on it. Nodes, like I indicate, are actually a bargaining chip for negotiation. So again, like I had said earlier, we have to be able to remove the position, the issue, and go to the position. The position we have that we need to harness is negotiation so that we recalibrate it to our language, and then it will be able to work for us. I'll let Mercy also weigh in on it.
Anne, can I just come in?
Before you come in, Cyrus, Mercy, anything? Or Cyrus can come in.
I'll quickly touch on the issue of, just to add on the issue of fees as well, and the proposition whether we are willing to cross over if there's a different way of managing it. The DAB mechanism as it is structured, and perhaps that's the mistake that FIDIC realized they had made in the 2017 book. That's why they introduced the green book, where now we can use one adjudicator as opposed perhaps to 3 or one DAB member as it were. That still fundamentally points to the fact that even FIDIC themselves realized that this mechanism may not be as efficient as perhaps they thought it ought to be. And therefore, having one in the green book or whatever may not really be it. The other thing would then be the issue around what then would be an acceptable alternative if at all we were even to consider these DABs at all, which we are saying we will not for purposes of today's discussion. And it's around the issue of perhaps having ad hoc, so that the DAB only sits when there's a dispute. And then at that point, then how does that interplay with other mechanisms of a similar or comparable measure like arbitration? Do you have them standing as opposed to, not instead of standing, they come in only when a dispute has arisen, as opposed to them being on a retainer? Perhaps that's something to consider for our perhaps our settings. On the issue of the question of whether this mediation as an alternative that we put out, a negotiation that we put out as an alternative to this current structure of DABs as set up, is this. It is the informalization and perhaps even almost infantilization of mediation, which we hold in high and strict regard on the African continent, that causes other dispute resolution mechanisms which are imported on the continent or to the continent are not indigenous to us, in the sense like this DAB causes them to be imported because we perhaps have not put mediation, the negotiation, and really quote unquote what we are calling Ubuntu methods of dispute resolution. We give them lower ranking. I'll say this continent has no shortage of engineers, it has no shortage of technical people in the subject matter of construction and the built environment. And that I can say, if you look at our listings of the engineers who even practice from this continent and from this region in other states, and even the ones who undertake majority of the projects actually from houses to bridges to roads, are done by local talent, not the big mega projects that perhaps you will see foreigners. And even then the foreigner is most likely the contractor, not really the engineer, the architect, the quantity surveyor, and other technical people. So we have these people and they can still carry out mediation. Mediation as it is envisaged can be done by really anyone who understands specifically people's skills. And an engineer can still be a technical person and a mediator. So we cannot infantilize mediation and say, would the mediator or the negotiator understand the technical aspects of a construction? They will, because these people also resolve these disputes on a day-to-day in their own capacity as engineers, architects, QSs, and technical people on the projects. So that there's no shortage of people who can mediate. They are already there because they're doing that work day to day. As such, we can't say that now, if we don't want DABs, will these people understand the technical aspects? They do, and they are doing it. So that is my additional point. Thank you.
Thank you very much, Mercy. This is very interesting, but we need to bring this to a close. Cyrus and Kenneth.
Okay,
Cyrus,
I just
you were
wanted
saying something?
I just wanted to say a few things. One is that the way the FIDIC contract is structured, negotiation can happen. There's what you call informal negotiation, and then there is the kind of negotiation which can happen after the notice of dissatisfaction has been issued by either party. That period just before arbitration. So negotiation can pretty much happen throughout the lifespan of the contract. The issue here is, okay, sometimes parties do not know that they are going down a slippery slope. What the board does, the board tells the parties, guys, can you discuss, can you kindly look into this matter, discuss it? What do you think about it? Is it potentially going to cause you a problem? And if the parties accept that it's actually could get them to a dispute, the board could actually tell them, look, can you negotiate this matter? And I give you 3 weeks, I'll get back to you. I think what the other side is talking about is already embedded in the contract, okay? I also want to give you an example on the mediation or negotiation that happens after the notice of dissatisfaction. One time I was in public office and a DAB issued a decision, and we, the employer, gave a notice of dissatisfaction and went into negotiation or mediation. I went to my boss and I said, sir, what shall be our position? Now, remember, this was a public infrastructure project. He closed his office, sat me down and told me, you know what, Cyrus, I'm actually not sure what to do now, because what exactly are we negotiating? We have a decision from a third party. The matter was black and white, okay? So if we are negotiating, what are we going to be negotiating? People outside there are going to perceive us as negotiating something that's going to come into our pockets, okay? So on public infrastructure projects, sometimes the people that are managing these projects are actually, whereas some methods seem plausible, it's actually very dicey, and they may not actually want to pursue those methods. I just wanted to say that mediation, for instance, has limitations. And if a matter is black or white, you'll rarely find a party going for mediation unless the matter is gray. So thank you very much, Anne.
Thank you, Cyrus. Kenneth, anything?
Yep.
I know you put a comment and you said that you thanked Belinda for agreeing with you. It's a price-setting issue. Set
Yes.
fees through regulation. Let's set regional fees for adjudicators and build capacity. Anything else you want to add on?
Yes, I want to add on the binding effect of any decision that arises out of the Ubuntu setup or even mediation. Those decisions are non-binding. So it leaves us with only arbitration and adjudication as decisions that can be enforced. Outside the time limit, an adjudication decision is actually possible. Thank you.
Thank you. I request that we mute. I request that we mute. Thank you. So there is a comment. There are comments in the chat. Faizo Mulama says, Madame Belinda agrees with DAB, but only wants it Africanized. I think he meant DAB with double A. What are the unique African points you'd want to see she doesn't mention? The NASA says there's a silver lining in the fact that EAC region is yet to adopt statutory adjudication. I see no harm in crafting enforceable DABs, especially for state-owned projects. The lacuna is a blessing. Then Julia says, thank you, Belinda. Infrastructure projects have a team of consultants managing the projects. These teams are able to resolve ongoing project management challenges on their own without bringing in more experts who will make projects much more costly. He agrees with building capacity. As Africans have been managing building contracts for close to 40 years, and at no time have I failed as the team leader of these projects to complete my project without resorting to dispute tribunals. Thank you very much. So Kenneth, Cyrus, and then Mercy, Belinda.
Thank you very much, MCIArb Kenya, our branch, and thank you very much, Madam Moderator. my counterparts on the other side, that is Mercy and Belinda. My parting shot is, now is the time for us as Africa to take heart, adopt DABs as an ADR, alternative dispute resolution mechanism, but also to transcend to statutory adjudication. I encourage whoever is on this platform that is has any way of starting up the initiative to statutory adjudication to actually join hands with CIArb and also CLI. Thank you very much.
Thank you, Kenneth. Thank you very much. Cyrus?
Well, I just want to thank the team from MCIArb Kenya. This is one of the very few workshops I've attended that has hit over 150 people. Actually, I think at some point we got to 170. I am pleased with the submissions that have come from the other side. Thank you very much, Anne, for moderating the event. I just want to say that I sat on my first dispute board in 2015. Yes, 2015. And I was on the side that was receiving the invoices from the dispute board, and they were quite high. But at the end of the day, there was value. I encourage any one of you who wishes to attempt or try the process, be part of it, and you will make up your own opinion at the end of the day. If you feel there's insufficient research for you to base on to decide whether boards are efficient or not. Thank you.
Thank you, Cyrus. Belinda, and then Mercy, and then I will take it up from there.
Thank you very much. I think it has been a very fruitful and spirited engagement. And whereas the proponents do have a good seed, a good idea, for us to grow it into a mustard, we have to accept that it cannot be as it is. We're not saying that is a bad idea. We're just saying it is an idea whose time has come to pass. It is an idea whose time Africa now needs to rise, to be able to Africanize, to make it culturally contextual and edible to us as Africans. We take the idea as a structural advice, we make it ours, and then we go on. Otherwise, like the Kenyan legislators have already gone away from it. It's only a matter of time until the other African parliaments also start going away from it. So let us borrow that cue and then have this team of experts in this forum come up and make it an African DAB that works for us and is also sensitive to our resource, cultural, and technological nuances. Thank you.
Thank you, Belinda. Mercy?
Thank you, and I thank the proponents for putting up a strong fight. And my closing remarks are this. These DABs have been sold to us as a method of construction dispute resolution. However, they have imported an expensive technocratic layer that does not sit with the African legal systems, public sector constraints, and public realities. I must then say that culturally also, we do not have a culture of dispute transparency and dispute protection in terms of construction, because contractors, particularly the smaller local firms, defer raising issues because of the power symmetry between the employer and the contractor, and therefore raising a dispute formally even to a neutral board signals adversarial tendencies and locks people from future contracts, and as such, this dynamic does not work. It was designed within a cultural context in which parties generally disregard dispute management as a professional responsibility. And therefore, this Ubuntu philosophy, which has been documented in various studies on mediation in Kenya, then is what I would say takes lead. The proposition has tried over the course of this debate to ask us to accept a mechanism designed in Geneva, refined in London, and administered in Paris, and call it efficient in Nairobi, Kampala, and the East African region. Before we do, we must ask, whose definition of efficiency are we looking at? Which environment are we in? Whose culture of dispute management are we following? And in whose and what capacity rather are we relying on? Until those questions are answered, the current DAB as it stands is not suitable for these jurisdictions that we serve in. And as such, until those questions are answered, I remain in opposition of the motion, and I stay firm that DABs are not suitable for use in this jurisdiction until we address the teething issues that have been raised by the opponents in the course of this debate. Thank you.
Thank you very much, Mercy. Thank you, our participants. We have heard from both sides. We've heard from the proponents, we've heard from the opponents, and they have both put up very spirited arguments. And dear participants, the jury is still out and the decision is ours to make whether dubs preserve relations, whether they're the quickest way of avoiding and adjudicating disputes in Africa, whether they are cheap, or as the opponents have said, whether they are expensive, whether they are not enforceable, whether they are fit for London and not for Nairobi and Uganda. The jury is out, and I would rather we take a middle line. How do we get the good from the dubs while maintaining the African context, while ensuring that the fees are affordable, while building our expertise? Because at the end of the day, construction disputes need a certain skill set, need to be resolved within a certain time, and projects need to go on, and relations need to be preserved. Thank you very much to FCIArb Kenya. Thank you for hosting us. I would like to hand over to Engineer Cherono. Take it up from here. Thank you very much.
Yeah. What a great debate by the panelists, and you've done a fantastic job bringing together some very experienced, very knowledgeable panelists. And to Cyrus and Kenneth, I know you are sweating over the spirited fight from the good ladies, Mercy and Belinda, but it was quite insightful. I just want to take a minute or two to make some remarks. And we've just come from Rome last week, where we had the international conference for the Dispute Resolution Board Foundation. I must say that our region is 30 years behind in terms of implementation of dispute boards, because dispute boards have been around for the last 30 years. And the world is thinking about how these dispute boards are going to evolve 30 years from now. I also must say that there is a major debate on dubs, and Africa being the continent where all the action in terms of construction is happening, then all these issues around dubs become extremely relevant. And I must say that never has ever been a time when the users to these dispute boards and be it private parties, be it lenders, be it the public, want their projects to be implemented within time, cost, and within schedule. And disputes remain a major risk for expeditious resolution of these disputes. What has been known, despite all these debates, is dubs have brought value, because all these other methods that we've tried have been tried in construction. At one point in time, arbitration was the go mechanism for resolving disputes, but it seldom worked for construction projects, because any day lost when you stall a construction project brings immense losses to the parties. And I think the whole agreement around the construction industry is to try to find a mechanism that avoids these disputes, and this is why DAABs have come in force. If you look at the latter versions of FIDIC that have been developed in the last 10 years, one of the FIDIC golden principles that cannot be amended is to have all formal disputes resolved through reference to DAABs. I must say that having an expeditious process for resolving disputes brings investor confidence, and there's no other time that our continent and our countries require really investments around this. There is need for value for money for all these projects, and for successful projects, all methods that must be explored are those that expedite the resolution of some of these disputes. I've had the need to carry out research, and it is true that our continent has very little data. You'll be amazed about the amount of data that is available on disputes out there in the Western world, even regarding disputes in our jurisdictions. Yet, very little research has been done within our region. So there is actually need to carry out some research to see how the numbers are coming out, and to see how these dispute boards have impacted on our projects. There's also need to upskill. There is serious lack of professionals in this industry. Dispute boards are completely different from the conventional methods of ADR that we have, because you will need to convert an arbitrator to somebody who avoids disputes, because arbitration actually comes after the dispute has arisen. But we need additional skills that enable management of these projects and to avoid the disputes, so that you also don't get to a level where you are moving to arbitration or litigation. There is also need for more awareness among the industry practitioners. We are speaking on a monologue most of the time, because we are speaking to ourselves as dispute resolvers. But let us not forget that we have contractors, we have employers, we have the parties whose dispute, where the dispute actually comes from. The dispute do not belong to the dispute resolvers, it belongs to the parties. And there is need for a lot of awareness around some of these methods. Finally, I must say, as the country representative or the Kenya's representative to the Dispute Resolution Board Foundation, we have an upcoming workshop in Kigali between 15th and 17th of July 2026, or in July, mid-July. And I want to take this opportunity to bring that to your attention, so that this conversation must continue. What I must say is we must involve ourselves in this discussion, because other people, considering most of the events that we've attended globally, are discussing a lot about our jurisdiction, and we are being left behind in terms of the discussions that go in place and those decisions that will finally affect the way we carry out dispute resolution. My name is Engineer Daniel Cherono. I'm a member of the Institute. I'm a fellow of the MCIArb, and I'm looking forward to having more conversations like this in future. Thank you very much.